Good morning, ladies and gentlemen. It is 9:30. Are we ready to start? I look at David and his colleague, yes. Welcome to this closing argument hearing. We should first see whether the list of participants corresponds to the persons being present here or connected. I will start with the claimant. Could you please confirm that all council and party representatives included in the list of participants are indeed present or connected?
Yes, Mr. President.
Thank you. And the same for the respondent?
Yes, Mr. President. I'm happy to introduce the members of our team if I would like to know who's who. I'm in your hands. But everybody's present.
Why not? Yes. We had the pleasure to see, I think, most of you, if not all,
Thank you.
at the previous hearing, but
To my right, you have already met with Ms. Ana María Ordóñez, who's the Directora de Defensa Jurídica Internacional de la Agencia Nacional de Defensa Jurídica del Estado. From the same body, you have Giovanni Vega Barbosa. I mean, maybe people can raise their hands as they give their name. We also have from the we have the director del Cuerpo Técnico de Investigaciones de la Fiscalía General de la Nación, Dr. Alberto Acevedo Quintero. And we have Ms. Sandra Montezuma, who is the asesora en el despacho del Vicefiscalía General de la Nación. So this is the prosecutor's team. And also Mr. Andrés Felipe Tinoco, also from the same body. And we have not in the room Miss Marta Lucia Zamora. The council team, you have myself from Gervani Fateh Michel Baya Disputes. You have Miss Jimena Herrera Bernal, who can raise her hand. You know her. Miss Pilar Alvarez, Miss Yael Ribko Borman, and Miss Carolina Barros. And we have also some trainees, Jad Mark Bawi and Cesar Rodriguez.
thank you very much.
You very much.
Now I turn again to the claimant to present your team, please.
Thank you, Mr. President. One mic can be on at a time. Oh, there we go. Representing the claimants, we have the principal claimant, Mr. Seda, who you're all familiar with. We may have other claimants join us at various points in time today, but given the time difference, I don't think they're on quite yet. I think it's 3 a.m. Where most of them are. To my right, we have Miss Annie Champion, myself, Rahim Molu, Miss Miriam Kaloun, Miss Ankita Ritwick, and Mr. Pierre Amariglio from Tenor Capital. And I do have 2 of my colleagues in New York, despite the hour in New York, joining us, Miss Nika Madioun and Mr. Ben Harris.
As you say, despite the hour.
Indeed.
Excuse me, Mr. President. Here, Secretary. Can I confirm that Kodian MSE, because there's somebody waiting in the Zoom waiting room, are your associates?
That's our conference room in New York.
Perfect. I'll
Yes.
admit them. Thank you.
Sarah, could you check with the non-disputing party whether they are connected?
Yes, we have one. Yes, we have one non-disputing party connected already. Mr. Álvaro Posada, I believe I'm correct.
Okay.
Álvaro Peralta, sorry, correction.
Okay. Very good. Housekeeping, claimant, any housekeeping matters from your side?
No, Mr. President.
Thank you. Respondent?
We do, Mr. President. With permission from the tribunal, we would like to address the issue of the rebuttal evidence that was excluded from the record. We understand, and you have also, of course, our email of 26 September, where we mentioned that we were proceeding with this hearing under protest and with the reservation of rights. It is a very important and serious matter for the state of Colombia. Therefore, Ms. Ordóñez will give you a statement on behalf of Colombia in this regard and put forward our position in this regard, if you allow us.
Okay.
Thank you.
Sorry, Mr. President. I wasn't under the impression that we would be dealing with this application first thing this morning. I had thought that we would deliver our closing submissions and then address the tribunal on the issue of the evidence, but we're in the tribunal's hands.
No, let's proceed in that order, and please, so the floor is yours.
Thank you, Mr. President. Dear Mr. President and members of the tribunal, as the Director of the International Litigation at the National Agency for the Legal Defense of Colombia, it is my duty to highlight before this tribunal some crucial considerations regarding the evidence that has been excluded from the file. As a sovereign state's representative, I will address you in Spanish.
Three.
Which channel?
English is 3, right? Okay.
There's no Spanish. It says Spanish.
Il faut qu'on parle.
It actually says two is just English.
Testing, testing, testing. T'entends quelque chose? Non.
Okay. Después de casi 4 años desde la recepción de la solicitud de arbitraje, varias rondas de escritos. Okay.
English is channel 3, not.
Yes.
Oh, I heard it.
Okay.
You heard? Because I'm hearing.
Not the chairman's.
Yes, could you please?
Okay. Thank you. Después de casi 4 años desde la recepción de la solicitud de arbitraje, varias rondas de escritos y una audiencia de 1 semana en la ciudad de Washington, teníamos la expectativa de presentar ante ustedes nuestros alegatos de cierre con toda la información que el Estado colombiano ha hecho el esfuerzo de recaudar para que ustedes, señores miembros del tribunal, contaran con toda la evidencia necesaria para adoptar una decisión justa que tuviera en consideración todos los elementos probatorios que hemos puesto a su disposición. Señores árbitros, si algo demuestra el 99% de tasa de éxito del Estado colombiano como demandado en controversias internacionales de inversión, es que Colombia es un Estado respetuoso de los derechos de los inversionistas extranjeros y del arbitraje de inversión como mecanismo alternativo, excepcional y especializado para la solución de controversias. Es precisamente por eso que, en cumplimiento de las diferentes órdenes procesales que ha emitido este tribunal, señores árbitros, ustedes tienen una responsabilidad muy alta en tiempos de crisis del sistema de adjudicación de controversias inversionista-Estado. La evidencia que Colombia ha puesto a su consideración les permite evitar que el sistema sea sometido a una nueva instancia de abuso, esta vez como consecuencia a fin de rebatir la declaración de Fanny Giraldo. La orden procedimental número 11 recordó que la admisión de la declaración de la señora Giraldo era permitida, ya que Colombia tendría la posibilidad de rebatirla y debía tener la última palabra en los asuntos de mérito, y por ello no ahorramos esfuerzos para recolectar la evidencia que nos permitiera, de cara a esta audiencia, rebatir lo alegado por la señora Fanny Giraldo. La orden procedimental número 11 explica, y es la razón de ser del sacrificio, debo decirlo sin precedentes, que ha hecho el Estado colombiano al poner a disposición del tribunal y de los demandantes información y documentación que compromete sus más altos intereses, incluyendo la seguridad e integridad de todos los miembros de la delegación colombiana y los abogados de Colombia. Como una muestra adicional de buena fe y de cara a las consultas con las partes para la eventual reconsideración de las decisiones del 22 y 26 de septiembre, hoy nos acompaña el señor Alberto Acevedo, como ya fue anunciado, director del Cuerpo Técnico de Investigaciones de la Fiscalía General de la Nación. El señor Acevedo ha suspendido su trabajo en relación con las investigaciones criminales más importantes dentro del Estado colombiano, con el propósito de resolver las dudas que el tribunal o los abogados de la contraparte puedan tener en relación. Muchas gracias por su atención.
Thank you very much. Any comments at this stage from the claimant?
At this stage, Mr. President, perhaps I can just make one offer, which is if this is really all about C-450, which is Ms. Giraldo's letter, claimants offer to retract that from the record if that would deal with all of their concerns.
Okay, that is noted. Do you want immediately to react or later?
Of course, this is not acceptable because it has been on record, it has been viewed by the tribunal. The tribunal has already seen that evidence, to the contrary of our rebuttal evidence, which the tribunal has not seen. So it's very easy now, if they're troubled by that evidence, which actually is very interesting for us, it's their option, but we cannot accept that our due process rights, which have been breached, be resolved by the withdrawal of a belated evidence they put and which triggered all of this and all of this effort that Colombia has gone through, as Mr. Ordóñez has just explained.
Thank you. So your positions are noted. You said this is a comment that, the first comment that you had, but you will be given the floor, of course, to comment in more detail at the appropriate point of time, either today or tomorrow. And the tribunal will, in any event, get back to the issue in the course of this hearing. So we now give the floor to the claimant.
Thank you, Mr. President. If you'll just give us a moment, we'll pass out the hard copies.
Can I have the connection for the laptop?
You talking to me?
No, to the AV people. Mr. Sachs. The HDMI cable.
It's the same,
Yeah,
but we
it's
just
the
got
same,
that
yeah.
account. I'm not sure, well, I'll take it anyway, but,
We can mail it to you afterwards.
no, but
if that's-
I'd rather work from the electronic.
No, I understood,
anyway.
understood,
It's actually easier to take notes on the.
understood, totally understood.
Before we start, if I may, Mr. President, I just see the almost 300 slides in 3 hours. I don't know if my friend and colleague will go through this. But if this is, I hope this is not a new submission because we really made the effort following the tribunal's instruction to hold to the 3 hours and to summarize and wrap up our case. And we hope that all of these slides will be addressed by claimant.
We will
Certainly.
see. Having seen and heard counsel for claimant in action, I would think that they will make it within 3 hours.
I hope that's not a comment on how quickly we speak, but we do hope to get through these slides. Is it up? Okay. I think we now have the screen up. Tribunal has what they need in front of them? Okay. Thank you very much, members of the Tribunal, for your time here today. It's been over 2 years since we started this arbitration, and we're here before you today to tell you many of the things that you've heard from us before. And the reason why I say that is because our case really hasn't changed since we filed this arbitration, and so many of the things you'll hear from Ms. Champion and myself today are things that you heard in the opening in May. And that's because everything that happened in the hearing confirms the narrative that claimants have put before you, because it's the truth. Because what has happened here is quite clearly a breach of the TPA, and our purpose here today is to show you, to walk you through some of that evidence that we heard back in May, and show how that confirms the case theory that we've advanced right from the outset. In contrast, I have to admit, I'm not really sure what we're going to hear from respondents this afternoon, because we have seen shifting sands over the last couple of years. Initially, and I think still today, their position has been that none of this is about the wrongdoing of claimants. You'll see statements in the record to that effect. And then we had a belated essential security objection. And even now in the letters that are being exchanged subsequently, you see mentions of illegality. I don't know if there's going to be a new illegality defense this afternoon. I actually am not sure. In preparing for this submission, I ask myself always, well, what are the main arguments so I can help this tribunal deal with the issues that are before them? And I'm not sure what we're going to hear this afternoon. It is a rare situation where I'm usually surprised. But one thing I have not been surprised about is when we say something, usually there's some action that happens shortly thereafter. So for example, when we said they're investigating Ms. Ardila Polo, they're investigating these certain members, Catalina Noguera, they closed those investigations a few months later. This case has evolved. But in preparing for this closing submission, I went back to where we started when we were first looking at this case, and when as anybody does, and that's the treaty. And I started from page 1 of the treaty. And it struck me, and I know we've seen some of this language, but it really did strike me when you look at the 2nd, 3rd, and 4th preambulatory clauses, what they say. Because it's a unique treaty in that sense. The US and Colombia came together to promote broad-based economic development in order to reduce poverty and generate opportunities for sustainable economic alternatives to drug crop production. Nobody is denying the history of Colombia, but what they wanted to do is they wanted to transition away from that history into a different future that promoted economic development, to reduce poverty, to generate legitimate business opportunities for people of Colombia. They wanted to create new employment opportunities and improve labor conditions and living standards, and establish clear and mutually advantageous rules governing their trade. And that is precisely what the investors here came into Colombia to do. They came in, and this is a situation where they had a successful investment. They built a hotel that was one of the most successful hotels in Medellin. It created jobs. It brought tourism to Medellin. And they were expanding that property development business to different areas of the country, creating jobs, creating job opportunities, and achieving these objectives that Colombia and the US sought to accomplish. And you guys have all seen, everybody in this room, members of the tribunal, you've seen the pictures of the Charlie Hotel. I hope that one day you'll have the opportunity to visit because it is a beautiful hotel. And it is one of the few luxury hotels in Medellin. It has an amazing roof deck that oversees all of Medellin. It, has a gorgeous restaurant on the main floor, on the rooftop. And it is by all measures, and the experts on Colombia's side agree, a resounding success. And its recognition has gone well beyond Medellin. Worldwide acclaim. If we go to the next slide. 2012, Condé Nast, Hot List. 2015, Spotlight in the New York Times. If you're spending 36 hours in Medellin, what do you do? Well, one of the few things they talk about is this hotel, the Charlie Hotel. In Vogue Travel, 21 reasons the cool kids Colombia flock to Medellin. I'm not a cool kid, and I even stayed at the Charlie Hotel for obvious reasons, but I can tell you that's where the cool kids do hang out. It is, by all measures, a wildly successful investment in the country. And Mr. Seda and the Royal Property Group expanded on this success. And what you see here on slide 7 are not renderings. These are actual pictures of the Luxe by Charlie, which is about an hour and a half away from Medellin, where they built several properties, and there was going to be a hotel that was the sort of pivotal project or property in the middle of this Luxe by Charlie development. And that was the next project that they sold out just as quickly. And people live in some of these houses. The problem is the hotel is in complete disrepair. It's 75% done, but at the time of these measures, that's when it came to an end, and I'll come on to that and I'll explain that. And then next was obviously the Meritage. And in 2012, Mr. Seda identified 56-hectare property between the airport and Medellin, and for a variety of reasons, saw that this was going to be a really interesting investment opportunity. It's a perfectly placed land just off the highway. A number of investments are being made in this area. The Avianca headquarters, you may know Avianca, one of the leading airlines in Latin America. Thousands of new employees were coming not too far away from where the Meritage property is. They were going to need housing. It was going to be a hub. It's 56 hectares, that's like a subdivision of a city. That's what was being developed at the Meritage. And these are renderings here, but that's what it would have looked like if it was going to have been done. And it was the best-selling project in the province of Antioquia. And this is not contested. In Mr. Seda's witness statement, he talks about the fact that in August 2016, they had pre-sold. They had already sold phase 1, 152 units sold. $34.2 million at the time. They expected to start construction on phases 2 and 3 at the end of August 2016. And at the time that these measures were adopted, there were 700 people that were benefiting from this investment. If we go back to the preamble, you don't need to change slides, but just to remind you, one of the key objectives was to promote broad-based economic development, to create new employment opportunities. There were 700 people working on the site at the time that these measures were taken. I feel bad for the claimants. I legitimately do, for obvious reasons. But I feel bad for the people of Colombia, these people who were working on site, who lost their job as a result of these measures. The development that this treaty sought to engender, to foster, it didn't come to be because of these measures. And that's why this is such a sad story. And when we think about what was the reason for this measure. How did this all come to be? Well, it all came to be because of the decision of one prosecutor. One prosecutor pushed that first domino that has us all here before you. And you heard from that prosecutor, Ms. Ardila Polo. And in her cross-examination, she accepted that it all was her. Ms. Champion asked her, so the decisions you made in your cases were your own? My own. My own. She said it twice. Just to wrap up the precautionary measures, the decision to impose those were entirely yours, to invoke those precautionary measures. And she said, correct. Just mine. Didn't go before a court. There was no, this was an administrative decision by one prosecutor. And Ms. Champion said, just to reiterate that last question, the decision to impose the precautionary measure was entirely up to you, correct? And she says, and that is correct. One rogue prosecutor pushed that first domino, and all of the following dominoes that we will talk about today then fell. And Mr. Lopez Montoya, who you didn't hear from in May, but I do think it's important to remind you of his testimony, he talks about what happened on August 3rd, 2016, because he was the representative of Royal Realty, who's the VP of Construction, who was on site when Ms. Ardila Polo showed up on that site. And if you read his testimony, it reminds you of a classic expropriation. All of the cases that we learn about, back in the 60s and even earlier about expropriation, he says the person informed me that several police trucks from the technical investigation team of the Office of the Fiscalia had arrived at the Meritage lot. That's what you think about, right? The police trucks roll in. He told me something to the effect of the prosecutors will arrive soon, and you should talk to them and see if you can resolve the situation. Of course, there was no resolving the situation immediately that day. As we now look back in hindsight, we see. But Ms. Ardila Polo showed up, and she introduced herself, and she put the padlock on the door, and from that day forward, everyone went home, and that was it. August 3rd, 2016. We didn't know it at the time, but that then crystallized into a breach, we say, in January 2017 when she issued the determination of claim. But she put the padlock on the door for the first time on August 3rd, 2016, and then said it's final as of January 2017. And unfortunately, you saw the renderings, but this is what the property looks like about 3 years ago. These pictures are about 3 years old now. And unfortunately, now the conditions are even worse. But you can see the degradation that happens to a site when you just leave it in disrepair. But you can see there was substantial construction works going on. There were several buildings that were mid-construction when that padlock was put on the door. I've been here. I've seen, in fact, I think Ms. Champion took these pictures. 700 people working on site. And now when you drive from Medellin's airport to Medellin, everybody drives by this. You can't escape this eyesore. And this sad story is for everybody who visits Medellin, all of the citizens of Medellin see it on a regular basis. They have a visual reminder because this is what they see. And immediately thereafter, after August 3rd, you can see on August 4th, August 6th, the leading newspapers, these are the headlines. Seizure of land plots where an exclusive project is being built in Medellin. The narco property in Antioquia that entangles a model. Complaint uncovered problems at the Meritage plot. That's the headlines. Widely reported, closely watched project. Given its enormous size, it's not surprising. But when these are the headlines, what do you expect is going to happen if you're a property developer? You think everybody's going to run to you and say, oh, when's your next project happening? Obviously not. What happens is that project is dead. The contractors have to be sent home. The banks come calling, and you can see on the next slide, we have Mr. Seda and Mr. Lopez Montoya's testimony. The banks accelerated the debt They pulled the additional financing, not just from this project, but from other projects. The unit buyers come knocking and saying, hey, we've put deposits. Give us back our money. They sue Newport. And Newport and Royal Property is entangled in this litigation, and arbitrations in country for the next 74 months up until to this day. That's what happens. That's what happens when someone goes and puts the padlock on the door and says, and there is a sign, nobody, do not buy here. That's the sign they actually, it's not metaphorical. They put that sign on the property. And at this time, and I showed you a bit of this excerpt, but I think there was some sound difficulty, so we'll try it without sound this time. And instead of hearing nice music, you'll have to hear my voice. I apologize for that. But at the time, they had promotional videos of Luxay going because it was nearly done. These are actually, this is, again, not a rendering. This is actually Luxay. Those are actual houses on the Luxay property overlooking the lake in Guatapé. They were 4 months away from the hotel being complete. They had hired staff. They were already booking events. There's a restaurant on the lake. Again, I've visited it, but you can see that's the restaurant right there. And it oversees. It looks at this, the Piedra de la Piñon. Sorry, I apologize to all the Colombians in the room, but they all know that it is a very prominent tourist attraction that I've been to in Colombia, and that's the view in Guatapé from the Luxay property. They had hired staff, and it was a truly going to be a magnificent resort location. But the hotel was 75% done. It was 4 months away from being completed. But what happened was, unfortunately, the financing was pulled because the bank said, we can't do business with you. We're scared to do business with you. Several other projects in the works. Tierra Bamba, 450 Heights, Santa Fe. In Santa Fe, for example, they had bought the land. They had the city planning director's endorsement in writing. There were dozens of people working at the Royal Property Group on all of these projects. That was what the Royal Property Group did. They had all of these property development projects. You can't view this as just the Meritage. It was a stream of projects that they had in their portfolio that were at various different stages of development. Luxay being nearly completed, Meritage, as we know, contractors on site, pre-sales of phase 1 done, and all of these different projects were at different stages of development. But this was a property development company that had several projects in their pipeline that all dried up because you need financing. And as you've heard from Colombia, if you're tainted, apparently you're supposed to Google them and you're supposed to find out as much information as you can. If this is what people are hearing about why Meritage was pulled, can you imagine any bank, anybody wanting to do business with the Royal Property Group when those are the headlines? Of course not. And ultimately, it resulted in the taking of a $255 million business that we are here today in front of you. I can tell you, the claimants would much rather have preferred to be doing what they do in their daily lives, building projects. But they can't do that anymore, and that's why we're here in front of you asking for compensation. And so what are the breaches of the treaty? On 19, 20, and 21, you have provisions that I'm sure you've all looked at: 10.7, expropriation; 10.3, national treatment; and 10.5, talking about the minimum standard of treatment, in particular, the fair and equitable treatment protection and full protection and security. Those are there for your reference, and we'll obviously go through each one in more detail. The first one I want to start with is expropriation. Because whatever this is under Colombian law, and I'm on slide 24 for your reference, whatever this is under Colombian law, I keep coming back to, as a matter of international law, this is actually a simple expropriation case. this is a taking. They came into the property and they took the project. It's as simple as that. It's an outright taking of the project. And of course, this treaty covers both indirect and direct expropriations, but in my mind, this is clearly a taking as a matter of international law. The question becomes, are there any exceptions from the obligation to pay compensation for a taking as a matter of international law? And I would suggest that there are very limited exceptions under international law, and that is if it was done in the exercise of the police power. So there's a police power, limited police power exception. But any public purpose is not a police power, and I'll come on to that. But I think it's hard to contest the fact that there was a taking. And what was taken? Well, there's two main things that were taken in our submissions. The first is the indirect interest that Newport had in the contract rights to develop and profit from the Meritage project. And the second is the indirect interest that Royal Realty, who was the management company, had in the contract, in its management contracts. Those were the two things that were taken from the Meritage claimants. And what was the thing that took them? Well, there's two things that we say effectuated that taking. It began with this certificate of real property seizure, which was July 22nd, 2016. Now, you'll remember, this was signed on July 22nd, 2016. Ms. Ardila Polo did not show up to the property until August 3rd. Ms. Champion's going to talk to you about the interesting things that happened between July 22nd and August 3rd. Some of the tribunal members may remember that. But that certificate of real property seizure was actually signed on July 22nd, 2016. Ms. Ardila Polo shows up to the property on August 3rd, puts the padlock on the door, and then says, yes, indeed, we are moving forward with this asset forfeiture proceeding on January 25th, 2017. You can see that date on the resolution for determination of the claims. And that's the date on which this crystallizes. It's at that point, it's stuck in the court system and you can't get out. Before that, there was a chance that the claimants could have gotten back their property, and they tried. They really wanted to. They took all of the diligence they did and they wanted to get this property back, but that was the point of no return in our submission. And we've heard this question of how long is long enough to be an expropriation? And there's case law on this, and we took you to some of this in the opening, but I've given you two examples here. Wiener Hotels, 1 year was enough. It just can't be an ephemeral taking. And in the Azurix case, they talk about in Middle East Cement how there was a suspension for 4 months. In SD Myers, there was a measure that lasted 3 months. But in each of those cases, the question was, is this long enough where basically you can't go back and do your project? You've lost your project. And 74 months later, here we sit, still no access to the property. And by the way, the property is on an early sale list. It's currently for sale. That is a taking. No, you can't go back and build this project. Nobody can go back and build this project today. The financing's not going to be there. The buildings are in disrepair. A taking has been effectuated. Certainly here, if there was an expropriation in Wiener Hotels, and in all of those cases reflected in Azurix, certainly 74 months is long enough. We've shown you the pictures, but I think it's important to note the land was previously authorized for early disposal on 4th December 2018. It was removed on 2nd July 2019, but as of July 1st, 2021, the land is back on the authorized for early disposal list, and that's, for the record, C435, reflects that it's on the early sale list. So they're selling the property. So in our submission, there has been a taking. And in our submission, it's an unlawful taking and therefore a breach of the TPA because it was done in a discriminatory manner or in an arbitrary way without due process and no compensation was paid. And it was not done to protect a legitimate public welfare objective. We're going to talk about all of those when we talk about the FET breaches. But for purposes of establishing that it was an unlawful expropriation, all I need to confirm for you, three gentlemen, is that there was no compensation paid. And there's no dispute about that. And on the next slide, you can see ConocoPhillips versus Venezuela. They confirmed that if there is no compensation paid, that is sufficient for it to be an unlawful expropriation. And in Colombia's rejoinder, they say no compensation was or is due to the claimant. So they don't dispute, nobody disputes that compensation has not been paid for this taking. And for that reason, we say it's an unlawful expropriation. So what under international law is the potential excuse that one can give to escape this compensation obligation? Well, the TPA gives us a clue at Annex 10B. It says, except in rare circumstances, non-discriminatory regulatory actions by a party that are designed and applied to protect legitimate public welfare objectives, such as public health, safety, and environment, do not constitute indirect expropriations. Now, what does this cover? We've seen contexts in which these types of provisions have been discussed. Generally speaking, they apply, obviously, to a non-discriminatory measure, but when is it non-discriminatory? It's generally a regulation that's adopted for a general regulation of general application. So for example, the Methanex versus US case, which I'm sure you will all be familiar with, where it's the banning of a toxic substance, for example, to prevent environmental damage or cancer-causing agent, for example. A general application, let's ban the substance. That's the kind of police power that is protected and usually then exempts you from the compensation obligation. This is not a general application regulatory measure. This is a targeted measure at one particular investment. And for reasons we'll come on to, it's not non-discriminatory. It is discriminatory, in fact. There's some guidance in the case law on what is a police power. So for example, in the Magyar versus Hungary case, a case which respondent also adopts in defining the police powers, they talk about two different narrow sets of circumstances. The first is measures of police powers that are aimed at enforcing existing regulations against an investor's own wrongdoing, where the investor's committing some illegal act or something like that. Or the second group, which is abating risks, again, to the public health, environment, or public order. And they concede, Colombia does, and I mentioned this earlier, that it's not the first prong. There is no wrongdoing of the investor at issue here. They say that in the rejoinder. They say, while it is true that the asset forfeiture proceedings were not initiated in connection with any wrongdoing of which Mr. Seda was personally accused, and not against any of the claimants, they accept it. They're saying there is no wrongdoing of Mr. Seda or any of the claimants. They talk about several irregularities in the chain of title. They're saying no wrongdoing on behalf of Mr. Seda. We're not accusing Mr. Seda of anything. Now, that's changed, as we know. But in the rejoinder, as recently as the rejoinder, they said no wrongdoing of any of the claimants here. Exercise your police powers as a matter of international law. The measures you take must be proportionate to the threat to the public order, and must be taken with due process. That is, as a matter of international law, in the Baghat versus Egypt case, that's just one example of cases where they've said it has to be proportionate. If there is a threat to public order, the action you take to deal with that threat has to be proportionate. We would submit that coming in and just seizing the property before even assessing good faith, that is not a proportionate measure to deal with, just even assuming that there is a legitimate public order threat here. What would have been the proportionate measure here? It would have been, let's go after the assets of the people who we say have done something wrong. Let's go after Ivan Lopez's assets. That would have been, if you want to protect the society against the illicit activity of Ivan Lopez, go after his assets. You don't need to go and prematurely seize this property. And I thought this was telling. They said, day one of the transcript at 269, counsel for Colombia said, the Colombian courts are seized with the matter, so let the courts decide. And at the end of the day, it may well be that Newport will be recognized as a bona fide without fault third party, in which case the precautionary measures will be lifted. Newport will be entitled to dispose of the land at that point in time. What they're saying is, they may get the property back, but is that a proportionate measure to the threat that they've identified? Shoot first, ask questions later? No, we say that is not proportionate, and therefore they don't come within the exception to the compensation obligation as a matter of international law. And when you see what Dr. Wilson Martinez has said, for example, in his second report, he says what would have made sense, what would have been the proportionate thing to do. The proportionate thing to do as a matter of even Colombian law would have been to go after those who were laundering money, those who you know were engaged in criminal activity. That would have been much less infringing on the investor's rights. That would have been perhaps a proportionate conduct. But to prematurely go and seize the Meritage project was not proportionate. Moving to the second argument, discrimination. The standard for discriminatory conduct, whether it's a breach of national treatment, fair and equitable treatment, or as a matter of expropriation, not being something that was discriminatory, the standards are largely the same in all of those cases. And claimants in Colombia generally agree on what that standard is, and that is when you have similar cases that are treated differently without reasonable justification. You can see that that's the standard that both parties agree to in their submissions. And you have to think about the comparators in a fact-specific and context-specific assessment. There's no, rigid test or anything like that. You need to look at the facts of the case, and all that this next slide does is tell you that. And in Colombia's opening submission, they tell you what that like circumstances are. What are those similar cases? And in their opening submissions, this is from one of their slides, they said at slide 192, it's assets affected by comparable wrongful conduct. So you're looking at the asset and you're saying, let me look at other cases in which similar wrongful conduct is infecting those assets. How are they treated? And similarly at the transcript, they said the same thing. They're looking at assets that are affected by comparable wrongful conduct, that have been affected by the same sort of alleged wrongful conduct, taking them at their word. We would submit there are three: the sister property, which we've talked a lot about, other Lopez Venegas properties, and other persons with a prior interest in the Meritage property, and I'll go through each of these briefly. We've all become very familiar with this diagram. It's only twice in this deck, I promise you. I'm pretty sure. Here's the first time. And I think it's important to start with this point. At the very outset here, in 1994, that first gray hexagon, that is a property that is co-owned by Ivan Lopez, by what they say is a front buyer for Ivan Lopez, Sierra Alta Lopez. Ivan Lopez, importantly, was never on title, by the way. Ivan Lopez's name was never directly on title. That's an important point. But they're saying Sierra Alta Lopez is a front buyer for Ivan Lopez. That's their case. And Entrelagos Orozco is the front buyer for Jaime Orozco, who is his half-brother. But that property is not 25, it's not like it's subdivided into 3/4 and 1/4. It's co-owned, jointly owned by both of them. And then it gets split into Lot A and Lot B. Lot A and Lot B are each, you can see there's a 75% and 25%. They're both still co-owned. Lot A is co-owned by the front buyer for Ivan Lopez, allegedly, and Lot B is 75% co-owned by Ivan Lopez. So the entire property is allegedly infected by this wrongdoing that they're saying, right? And everything that goes forward is then a reconsolidation of and a division of that property that was co-owned, the entire property, including the sister property, which is Lot A2. You can see that on the bottom in the blue. Lot A2 was at one point owned 75% by Ivan Lopez. It was then owned by the fruit seller. It was then owned by the engineer. All of those things that they talk about in the provisional measures application, in the requerimento, in the determination of claim, they all equally affected both the Meritage property and Lot A2. And when asking Ms. Ardila Polo about how did she come to this, what investigation did she do when she was looking at the Meritage property? And she said she had 2 title studies, and she refers to those 2 title studies. She said she had one title study from Otero and Palacio. That title study is on the Meritage property, okay? And this is important. And they had a title study from Guzman Monroy. Now, where did they get that title study from? Guzman Monroy is actually a title study on the sister property. Guzman Monroy must have been given to her by Ivan Lopez, because our folks didn't have the title study by Guzman and Monroy, but she has 2 title studies that she had looked at when reviewing the Meritage and the sister property. And since then, we've been able to get a copy of the Guzman and Monroy title study, and it is at C30 bis. And the Guzman and Monroy title study on the sister property gives a favorable opinion. So she's got one title study on the sister property that says favorable opinion. And she has the Otero and Palacio title study. And guess what that, on the Meritage property, and guess what that gives? A favorable opinion. 2 title studies, one for the sister property, one for the Meritage, both favorable opinions. And she goes after the Meritage property and leaves the sister property. So if she assumed that, oh, well, this favorable property, this favorable opinion means they must be good faith buyers, or whatever conclusion she came to, the Meritage was entitled to that same conclusion, if that's what she based her assessment on.
Rod, for a second. You're not questioning.
Pull your microphone down.
Can you hear me?
Now I
Okay,
can.
sorry. You're not questioning as such the fact that a prosecutor may do this in this case and that in that case. The point you're making is that by joining this difference of treatment in your view with regard to the 2 plots or the 2 divisions, then it becomes discriminatory under the treaty. But you're not asking us to review what the prosecutor did, right? I mean, I'm slightly leading, but
Yeah, no,
I just
no,
want to
no,
make sure that I understood your point.
All I'm sorry.
I'm not up to a point. My question is a leading one, but I just want to make sure that I understood the point you're making. You're not asking this tribunal to review or to assess the actions of the prosecutor as such, but only to the extent that joining them together leads you to the conclusion, which we will share or not, that this constitutes discriminatory treatment under the treaty, right?
For purposes of assessing the discriminatory conduct, that's absolutely right. You do not need to review whether or not they made the right decision. All you need to come to the conclusion of is, were there similarly situated cases that were treated differently? And was there a reasonable justification for that? And we say there were similar situated cases, for the reasons that I've explained, that were treated differently. One, asset forfeiture was commenced. The other one has been left as is, has not been taken to this date. And there's no rational justification for that differential treatment. That's correct. We're not asking you to say, should they have acted against the other property or not? That you do not need to come to a conclusion about to assess whether or not there has been discriminatory treatment. But one important fact here, if you look at the reconsolidation with the engineer, At that point, it is in the hands of Jose Ignacio Cardono, right, who is said to be Paraloca, or the front buyer, sorry, for Paraloca. It then gets divided and is repurchased by Entrelagos Orozco. You can see on the blue the green square there. So he rebuys this property from Jose Ignacio Cardono. So he acquired A2 from the engineer, and obviously, if anybody knows about this history of title, it's the guy who's the half-brother of the alleged narco-trafficker, right? So how can you possibly say that we have no evidence that his 25% was not infected? He repurchased it from the engineer, who they said was the front buyer for Paraloca. So I just don't understand that explanation. Slide 53 was in the determination of claim, January 25th, 2017. That's the document that we say crystallizes this breach, right? And in a sworn declaration of Jose Ignacio Cardona, who's the engineer, they get a testimony from him. And he says, following that meeting from Mr. Jaime Orozco, he contacted me to make a proposal by which he wanted to undertake parceling of the lot. He told me they wanted to avoid being involved in those proceedings. And so he says that I should reconsolidate and all the rest, and then I deliver to Ms. Tatiana Hill, under orders from Mr. Jaime Orozco, the 83.9%. That's his testimony. That actually the person orchestrating all of this is Mr. Jaime Orozco. Ms. Ardila Polo knew this at the time of the determination of claim. That's actually in the determination of claim. She has this testimony. How can she possibly have testified to you what she testified in May? I had no evidence that Mr. Jaime Orozco had done anything wrong, that he was involved in any illicit activity. She was told by the engineer, she wrote it down, she drafted the determination of claim, that Mr. Jaime Orozco was the one who was organizing all of this. And in fact, and now I'll go back to 52, Ms. Champion asked her about this. All of that activity is directed by Jaime Orozco, correct? And she said, yeah, based on the information given by the engineer, Jose Luis Cardona Rodriguez, yes, that is the information he offered. It seems like she's giving him a presumption of good faith that well beyond a presumption of good faith that was certainly not granted to my clients. If there was one of these properties that you should have gone after, it was the sister property, not the Meritage. What other reason did we get for why they haven't gone after the Meritage? We have the Cartier apartments, which was under development, because one of the things they said was, well, this one was under development, so that's what made it unique. The Cartier property, Ivan Lopez purchased in the 80s, and then he transferred it in 1994 to none other than Promotoro Sierra Alta, which presumably is also a front buyer for Ivan Lopez. And then Promotoro Sierra Alta sold it in 1997. And there was property being built on the Cartier developments. Did you go after that one? No, they didn't go after that one. Various other banks and fiduciaries did business in that particular property. Personally owned by Ivan Lopez in 2007. In early 2009, Scotiabank, Colpatria, one of the largest banks, acquires a mortgage on that property. They would have done some diligence. Another fiduciary sold property owned by Mr. Lopez August 2019. During the pendency of this proceeding, banks, Banco de Bogota, one of the largest banks in Colombia, is doing business on properties in which Ivan Lopez has previously been an owner. That's the third comparator group. Because Dr. Wilson Martinez and others say the right thing to do is to actually go back and trace the history back and figure out who was not a good faith buyer. That's the person whose assets I'm going to go after. But they haven't gone after anybody else in the chain of title. And just on the next slide there, you have a couple of cases. Discriminatory intent is not necessary. We don't need to show why, there is a discriminatory conduct. That intention is irrelevant to assessing discriminatory conduct. We have some explanations to offer you in a bit, but it's unnecessary for your finding. And so Colombia, we submit, has discriminated against the Meritage claimants as compared to the three comparator groups by applying a different standard for what constitute an alleged illicit origin and by failing to consider the Meritage claimants' good faith prior to seizing the Meritage property, which appears to be what they are doing with respect to the other comparator. But they're assessing perhaps good faith, but we were entitled to that same treatment. And that's a breach of the national treatment protection. That's a breach of the FET protection. And that makes the expropriation unlawful for yet another reason. So they say, well, how can this be justified, right, is one question that this tribunal might ask. Is there a reasonable justification? And we would submit there is not. But the two explanations you've been given are, we have to prioritize because there's limited resources, and in this case, there's some urgency because this is a development in progress. But neither one of those hold any water. Why? I'm here for your reference, but there are a few provisions of the asset forfeiture law that are really important to assess this due process standard, a breach of the due process standard. Good faith is presumed in all legal action or transactions. There's a presumption of good faith. And when does this good faith assessment need to be done? Well, Article 118 says that it needs to be done at this initial stage, right, before a determination of claim. One of the purposes of the initial stage you can see on 118 is 5, search for and collect the proof which makes it possible to reasonably conclude that there is no good faith without fault. That's the first thing you do during the initial stage, according to the asset forfeiture law. The provision on precautionary measures, Article 87. The purpose of precautionary measures. The very purpose, that last sentence says, is in any case, if you're taking precautionary measures, in any case, the rights of third parties acting in good faith without fault must be safeguarded. When you're taking precautionary measures, you must safeguard parties acting in good faith. And by the way, if you do take precautionary measures, how long can they last before you issue a determination of claim? 6 months. So that initial phase has to be done by that point, at which point you must certainly have assessed good faith. 152, whose burden of proof is it? Who does this investigation? Is it the courts? No, it's not the courts. It's the Office of the Attorney General of Colombia has the burden to identify, locate, gather, and file the elements of proof which show the existence of some grounds set forth in the law for the declaration of forfeiture, and that the affected person is not a bona fide owner of rights without fault. That is an obligation on the Attorney General to do, according to the asset forfeiture law. And Mr. Medellin and Mr. Wilson Martinez confirm, doctors, sorry. I'm glad they're not in the room, otherwise they would have corrected me. Doctors Medellin and Dr. Wilson Martinez confirm what I just told you, that before you take precautionary measures, you must assess good faith so you don't harm their rights. You didn't hear from Dr. Medellin, unfortunately, but he was a former Minister of Justice. He was the father of the asset forfeiture law, former ambassador of the UK for Colombia, highly regarded. He was the legal advisor to the Attorney General, in fact, on issues related to asset forfeiture when they were implementing and enforcing the 2014 asset forfeiture law. So one of the leading experts, and unfortunately, you didn't have the opportunity to hear from him. No problem. And even when you hear from, this was a little bit misleading, so I just do want to correct this. In Colombia's post-hearing brief, they said what you see in paragraph 175, the Fiscalia was not under an obligation to confirm the existence of bona fide third parties upon the adoption and imposition of the precautionary measures. That was their position in the post-hearing brief, despite what I just showed you. And they say, as acknowledged by the claimant's expert during the hearing, asset forfeiture proceedings are initiated by a finding that the origin of the asset is tainted by illegality. And that 282 footnote, you can see, refers to this excerpt of the transcript. And so I just wanted to show you that excerpt of the transcript where Dr. Martinez said, indeed, when carrying out asset forfeiture investigation, the first thing we run into are assets. The first thing that is investigated is the origin and the destination of those assets to determine.
Slow down.
Sorry.
And first thing what?
That is investigated is the origin and the destination of those assets to determine whether they are tainted by illegality. If that is the case, they can move on with the investigation. But if not, that asset forfeiture action has come to an end. But if you look what he went on to say at line 12, he made clear, when the investigator, the operator, finds that the tainted asset is in the hands of a third party, a good faith third party, clearly they cannot go after that asset. And so I asked Dr. Caro, did you assess Newport's good faith? Did you? At any relevant point in time? Because in the requirimiento that he authored, nowhere in there is there a discussion about Newport's good faith. And I asked him, show me where it is. And he couldn't show me anything. I said, but you cannot point me to anywhere in this decision, right, that specifically discusses independently Newport's good faith status. And he said, that's right, because Newport was tied to Corfi Colombiana. So he's saying we assessed Corfi Colombiana's good faith, not Newport's, because we didn't need to assess Newport's, because Corfi and Newport are tied together. And I said, but it's not the same standard for everybody. You put yourself in the position of the person who actually conducting the diligence. And he said, of course, the standards are different. And of course, Corfi and Newport are different. So he should have assessed Newport independently, but irrespective of that, the standard of a fiduciary and of Newport were different. So even tying them together, even if you could tie them together, it wouldn't make sense. They just did not assess Newport's good faith at all before they seized the property. And in fact, then it went to the asset forfeiture court. The asset forfeiture court said initially, no recognition of the impacted party is conferred upon Newport. That's what they initially found in August 2017. And it was not until April 22nd, 2022, just before the hearing, that the Superior Court of Bogota said that it concluded Newport is entitled to participate in the case, given that it has a pecuniary right with respect to the affected properties. And so they effectively found, and they refer to Article 30 here, and Article 30 talks about affected persons. And their rights must be assessed. Their good faith status must be assessed. And that's why Colombia has to say the following, and this is the quote, and I come back to it, in their opening. Now what they say is they accept. Okay, well the courts have found that they're affected parties. Now let the courts do their thing. The Colombian courts are seized of the matter, and our friends on the other side are not claiming the judicial process in Colombia is wrong. So, and in fact, they're very happy of the decision in April, 2 weeks ago. And let the courts decide. Let the courts take this normal course of what an asset forfeiture proceeding should be, and at the end of the day, it may well be that Newport is recognized as a bona fide, without fault, third party. The precautionary measures will be lifted, and they'll get their asset back. That's what they're saying now. But it's too late. It's too late to give it back. And by the way, from a due process perspective, it's the wrong order. You don't shoot and ask questions later. You have to assess someone's standing and their rights and assess whether or not they acted in good faith beforehand. And that's exactly what the case law says. In SIAG versus Egypt, they said it is important to note they're talking about an Egyptian court decision. It ruled that the decision to issue resolution number 83 before the specific date was without any legal basis in all respects. The tribunal finds that claimants accordingly suffered a denial of substantive due process. They assessed this context of even court conduct as being potentially a breach of due process rights. And when something is not carried out in accordance with the domestic law, it is a breach of the due process rights, and that's what Quibarax versus Bolivia said. But even more importantly, when you look at ADC versus Hungary, what they say is an actual and substantive legal procedure for a foreign investor to raise its claim against the depriving actions already taken or about to be taken against it must come first. You need reasonable advance notice, a fair hearing, and an unbiased and impartial adjudicator to hear your case as to whether or not you are a good faith purchaser in this case. That must come first before the measure. That's what ADC versus Hungary found when it was assessing due process. Similarly, in Rumeli versus Kazakhstan, they said in that case, the decision at hand, the measure that was taken, was made without giving claimants a real possibility to present their position. They have to be given an opportunity to be heard before the depriving measure takes place. That's due process. You don't get surprised by someone showing up on your lot and putting the padlock on the door. You should have the opportunity to present your case. I am a good faith party, not 74 months after it's been taken, but before the measure is taken. That's what international law requires. In Deutsche Bank versus Sri Lanka, again, paragraph 487, CL 87, Deutsche Bank was not informed of the case against it before the Monetary Board issued its stop payment order, and it was not offered the possibility to respond to the investigation report. Again, another case where the measure was taken and before the claimant had any opportunity to be heard at all. That is not due process as a matter of international law. And all of those cases confirm that the timing matters. The depriving measure cannot take place before you have an opportunity to be heard. And the claimants are only now going to be given an opportunity to be heard. They're saying, well, they're going to be given an opportunity to be heard, but it's the order of things. You can't be given an opportunity once you've already been deprived of your rights. And so that breaches the due process rights of the claimant.